Good afternoon, good morning. Not legal advice. I think I have to say this now very clearly. This is opinion only. Make your own decisions. Thank you very much. What I was going to talk about today was I've seen people referencing the status of or their opinion, I think more so about the litigation that's ongoing. And I wanted to give everybody kind of an update in terms of where it actually is, and so we will all have kind of a view, understanding of what's going on, or timing. But of course, before I get into that, as I do on all these wonderful videos, what's the difference between Elon Musk and a lemur? Elon Musk made the electric car. Lemurs, Madagascar. Ouch. And I think some of these are going to be like that. If Dodge made an electric car, would it be called the Dodge Chargeable? When driving an electric car, never, ever, ever go onto a dead end street. You'll be stuck on a road with no outlet. And last but not least, why did the electric car run a symphony orchestra? Because it knew how to conduct itself. Thank you very much. And I apologize. So, since the last at least the last video I recorded, and you could obviously see I don't edit these videos, so they come straight out, do one shot, and here it goes. Sometimes with notes, sometimes without. I have some notes today, so I'll refer to those. Last filings that were made: June 20th and two on June 21st. June 20th filing was by Tesla, who again is a nominal defendant, means they have an interest in the outcome of the litigation, but they're not the main defendant. And what the request that was filed on June 20th was to set aside the ongoing briefing schedule. So just to bring everybody up to speed, we had an ongoing matter in Delaware challenging the pay package. The court ruled against the pay package. The issue of attorney's fees for plaintiff's attorney is still being briefed and is ongoing. So that's where we were. There was a hearing that was set for July 8th coming up that was supposed to be the deciding date, or at least the hearing date, on the motion for attorney's fees. Tesla, in their filing on June 20th, said we shouldn't go forward with that hearing on July 8th. What we should do is we should set a briefing schedule. In other words, say when parties should file their briefs about the impact of ratification. And Tesla goes on to further state or suggest that now, because of the ratification, which was a fully informed vote, that the prior judgment of the court no longer has an effect, and the attorney's fees issue is also impacted, at least dramatically. And before there should be any further decision in this case about the merits or attorney's fees, there should be a decision about the impact of the ratification. So, and they also ask, and the last part was they asked for an expedited briefing schedule. In other words, not a long time to brief all these issues about the ratification, but at least set it up now. So that's June 20th. June 21st, and it was due on that date. So Tesla was interesting. They kind of undercut the plaintiff by filing that June 20th. That was an interesting timing element. June 21st, two filings, one related to the motion for attorney's fees. This is now plaintiff, the party bringing the action, and it's really the plaintiff's attorneys, who we all know this action is really run by. They filed a reply brief, which is customary and appropriate, although it's 54 pages long. So that's a long reply brief. And it's basically, again, reconfirming in their mind, and I put that in quotation marks, why they are entitled to the attorney fee award that they claim. They focus on the timing that the calculation of the conferred benefit is to be made. They say it's today, as opposed today or in the near term, as opposed to when the issue was first granted or when the issuance was. They argue that even the option grant is not calculated properly. They reference that the return of the shares is an anti-dilutive event and is valued to Tesla's shareholders, and just bringing back the 300 million or so shares, that's the benefit. They don't talk about what happens the next day when that benefit is so temporary. But I think their position is that as of the day that they got the judgment, that was the benefit. And what happens afterwards doesn't impact them, and they're not responsible for it. Now, I found this reply pretty difficult to read and to follow. 54 pages, it's way too much. They do reference some analogous cases. They talk about one case, but it involved a much smaller sum, where if you broke down the hourly fee, it was something like 35,000 hours. And they try to justify their fee. They also try to indicate that lodestar method, which is number of hours times the rate, shouldn't be used at all, and that when you look at quantum merit, the reasonable value of the services, that's kind of a backdoor method of trying to use that lodestar method, again, hours times rate. So that's kind of their sum and substance. In the end, they think they're entitled to whatever they asked for, and they also reference that it shouldn't be challenged, and it's in this and it's in the other brief. They question the validity of the ratification period, although it's obviously not before the court yet. And then they do suggest that the prior interactions with the court, including the May 28th letter, limits what can be challenged. So that's kind of it. And they basically end up at the same boat. They claim that they provided that, even if it's for a millisecond. Their position basically is, if it's for a millisecond, we provided that benefit, and it doesn't make a difference what had happened after. Seems kind of like a rather absurd and over. I mean, just one of these black and white. Seems like it's not very well thought out. And again, the brief itself, 54 pages long, really was difficult to follow. I don't think it was particularly well written. Again, it focused on the dilution impact of undoing the transaction, but it didn't really address with the deal with the idea is what was the permanent benefit. If you have a benefit for a millisecond, is that really something that should justify this kind of fee? Is that really the benefit that the courts in Delaware really are looking at? Because in this case, even if there was a benefit, it was just just moments. And now there's the issue about the ratification. Will that eventually be heard? We don't know. I assume somebody's going to challenge it at some point in time, and maybe we'll get a ruling. And maybe there could be litigation in Texas as to this also. I don't know, because obviously now Texas has jurisdiction over Tesla and any disputes. And it would be interesting also if, in fact, there was another pay package dealing with 2018, so now not a ratification. Would that pay package be subject to Delaware law? I think maybe not. It might be subject to Texas law at that point in time, but it would be a new pay package. Also, I'm just throwing this out. Also, if for any reason this went all bad, and I'm not telling anybody what to do, but if for any reason this all went bad against Elon, he probably, and I don't know how this would work out, but he probably would have a claim against Tesla for the reasonable value of his services over those years. And what that number is, I have no idea, but he would get compensated, and I would expect that he would pursue that in a friendly way, that he is entitled to it. Maybe it would be very friendly litigation, but I think he would be entitled to it. So in other words, if you couldn't do the same pay package over again, if a court found that it was entitled to the same amount of money, that's another way of getting to the conclusion in a different way. But anyway, that's kind of down the road, and we haven't got there. So that's if somebody challenges the ratification. Somebody could challenge the move, but again, the TripAdvisor case, that was turned down, but the court did leave open the possibility that there might be some circumstance. But if Tesla's already moved, I don't know if they could bring them back. They might be able to block a move, but not bring it back. So that might be the distinction. So that's one 621 filing. The second 621 filing related to the scheduling order. So the first one I mentioned, Tesla was objecting to the existing scheduling order where there was going to be a hearing on July 8th. This last document filed by the plaintiffs, or in this case, the bad guys, was dealing with the same issue. And it says basically, again, we don't agree that ratification changes anything. I just summarized 15 pages. But if the court wants to hear briefing about those issues, it laid out a schedule and suggested to the judge, make June 27th the date that we have to file our brief, and make July 3rd the date that Tesla has to file their brief, and we'll keep everything on schedule July 8th. That's the last filing. So today is June 22nd. They've asked for a briefing schedule that starts in 5 days. So they may, in fact, I would guess, with that time frame, they're working on their brief now. And so that if the judge on Monday says, okay, I'll agree, we'll hear the briefing, we'll give briefing, and then we'll hear the matter on July 8th. But they would have 2 days to get it done. So my guess is they're probably working on it right now, and they'll wait and see how the judge rules on that. The judge could say that we're not going to brief, but it might be safer for the judge so the record looks complete and proceedings look fairer if she lets everybody brief the issues. So it's in front of her, and then she could find however she wants. She could say that the ratification is not before her validly, and if somebody wants to bring an action to get a declaration of its legal validity, they can do that. Or she could say yay or nay on it, I guess. If so, I don't really think that she has jurisdiction over it at this point in time, but that's just my humble opinion. In other words, I don't think she has the issue before her as to ratification properly. Just my opinion. But what she does is what she does, and we know that she has a particular angle on this case. I predicted previously that I think she will be off the bench before this case gets a final resolution. Final resolution. In other words, she might make a ruling, but I think there's a likelihood, depending on the ruling, that ruling could be changed after she's gone, and that would be either in some kind of. I would expect her to go to a private firm. Just my expectation. But they're asking again. They're asking for the proceedings to go forward. This is plaintiff's counsel because they want it because they got a lot of money at issue. Because this case is all about plaintiff's counsel. This whole case. It's not a case about someone dying because of water in their little town and a class action being brought and the lawyers being really instrumental in generating a benefit from that. This is just, this is the way I see it. Plaintiff's attorneys with a strict money grab. And it'll be interesting to see how the judge tries to justify her decision and if she's impacted by what seems to be in Delaware a little bit of a change in terms of their recognition that they have problems. Although to date, I don't think any of the changes or proposed changes deal with claims involving breaches of fiduciary duty, like was the underlying claim here. So kind of brings you up to speed. Let me quickly summarize. 3 briefs filed, 2 about the scheduling, what to do in the future, 1, a reply brief as to the attorney's fees. The plaintiff's attorneys wants the judge to set a briefing schedule for the issue of ratification if she wants to hear that issue for June 27th and July 3rd. If she's going to do that, she will have to do that probably in the next couple of days. The hearing on the attorney's fees is set for July 8th, And depending upon what happens in the meantime, because that's only a couple of weeks out, 2 or 3 weeks out, but depending on what happens in the meantime, that will control whether there's a hearing on the 8th or whether the judge wants the parties to provide briefs as to ratification, or if the judge has reached a decision. I hope that provides clarity. If anybody has questions, please let me know. And I obviously am following this. And as I see procedural changes, so everybody kind of has an idea of what's really going on, I'm not going to make any projections as to how I expect it, but I did reference one of the documents in this particular video. Hide the ball. Anyway, take care, everybody. Have a great weekend. Again, if you have any comments, questions, please feel free to put them. If I can answer anything and provide further clarity, I will. Have a great weekend. Be well. Take care.